Allahabad High Court APS Series A Exercise 22 at the speed of 110 words per minute. Be ready? Start. Crime prevention is an oft cited but least studied aspect of our criminal justice system. Examination of crime prevention from the victim's perspective is even rare. Among other methods, situational crime prevention through risk mapping and vulnerability mapping stands out in terms of viability and efficacy. A truly effective criminal justice system can identify potential victims and to put measures to protect them in a place before the incidence of crime itself. Capacity building and effective implementation are key to such endeavors. Stop para. In a post crime scenario, however, there is a need to shed the image of the victim as a mere witness and to institutionally recognize their rights and requirements. The same thing can be achieved through a legislative recognition of the following points. First, the conceptualization of access to justice for victims requires viewing such access less in terms of directive principles of state policy under Article 39A and more as a fundamental right under Articles 14 and 21. There is an urgent need to strengthen the complaint mechanism for non registration of FIR under Section 154, Subsection 3, Code of Criminal Procedure, and extension of Section 166A C in the Indian Penal Code to all cognizable offences. Further, access to justice also requires the creation of victim friendly procedures that are aimed at reducing their inconvenience. Stop para. Second, it is imperative to recognize the need for effective victim participation. Currently, the victims and their counsels are entitled to extremely limited participation in line with the global trend. There is a need to recognize the right of victims to be heard at all appropriate stages of a trial. Victim impact statements can help accord this right. Moreover, substantiate access to justice also requires access to legal aid. Such legal aid has the potential to culminate in effective victim participation if provided to the victim from the stage of reporting to the stage of sentencing and appeal. Stop para. Third, such legal aid to victims is also imperative for function of their right to information. The right to information in turn enables their access to all other rights. Ergo, victims must be entitled to information regarding their role in the criminal justice process, what they can expect from the criminal justice system, status of the trial, and also their other rights and entitlements as a victim of crime. Stop para. Fourth, the right to information can also go a long way in securing the right to protection. The victim must be kept abreast of all developments in the trial process which may potentially compromise their security. This would require intimation of the victim in connection with any hearing changing the nature of the accused's custody, including his release on bail or parole. The framework for such intimation is already available to specific victims in Section 15A of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. Other measures for witness protection such as relocation and change in identity as provided for in the witness protection scheme to need to be reviewed and enforced effectively. Stop para. Fifth, the concept of assistance as envisaged in the 1985 UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power needs to be recognized as a right, not merely for victims of rape and acid attack, but for all victims of crime in general. The state must play the role of facilitator in providing to the victims all such assistance as is necessary: medical, psychological, financial, and material. Stop.